Welcome to Course 1 of Mr. Cannabis Law's Cannabis coursework. Today we're going to be talking about history and policy. Now, as an attorney, it's great to understand the what, right? That's the rules, the statutes, the data, but it's even more important to understand the why. And that's where history and policy comes in with respect to cannabis. And history and policy plays such an important role in the cannabis industry and really as your practice as an attorney. So in order to really provide true value for your client, you really need to understand the why, and that's the history and the policy. But first, what I want to do is I want to take you through the what. And the what starts with cannabis. Cannabis is a plant. Right? We all know it's a plant, but what the law has done since the 2018 Farm Bill is it's broken it up between hemp and marijuana. Now, the way it makes this distinction is based on delta-9 THC. Delta-9 THC is the cannabinoid that creates the psychoactivity in your brain when you consume cannabis. In other words, it's what makes you high. So delta-9 THC is what's getting all the attention right now, and that's what all these laws are based off of, is just simply what delta-9 THC content is in this cannabis plant. If it's 0.3% or less delta-9 THC, then it's going to be considered hemp. If it's more than 0.3% THC, then it's going to be considered marijuana. And this is very important about whether you're dealing with a client in hemp or you're dealing with a client in marijuana. In fact, when clients call me, the very first question I ask is, are you a business in hemp or are you a business in marijuana? The reason is because marijuana is still a Schedule I compound and it is federally illegal. In contrast, hemp, since the 2018 Farm Bill, is now federally legal. So once again, whether you're dealing with a client with hemp or marijuana is extremely important, and you need to be aware of that right up front. Now, the marijuana legal framework is highly restrictive. Very hard to get a license in marijuana. Hemp, on the other hand, much less restrictive, much easier to get a license. As a result, a marijuana license has a lot of value. If you're able to go through that competitive process and win a marijuana license, a lot of value. And if you're able to do that for your client's going to pay you a lot of money to get one of those licenses. Hemp, on the other hand, since it's not a very competitive process, you're not going to charge a lot for these licenses. You could very easily get a license. Your focus on the hemp side is really more helping on the operational aspects, the go forward plan after you get a license. So what I want to do is I want to kind of show you where these two areas kind of break down, because each one of these areas is a different business segment, a different type of law, and a different history and policy between all of them. So we're going to start with marijuana. Marijuana could be broken into medical, adult use / recreational, and then spiritual and sacrament. So really what happened with marijuana history and policy, and we'll get further into this, is it started with medical, and then what we're seeing is now a shift towards adult use and recreational. Now, in the cannabis world, spirituality and the sacrament doesn't play quite as important a role, but the reason I put this up here is because if you are a cannabis attorney, you will probably at some point also practice law with respect to psychedelics. And in the psychedelic industry, what we're seeing play out is mainly this versus this, not so much this. So it's very important as I go through this presentation and as we go through this coursework, I'm going to kind of identify little areas where psychedelics play into the coursework as well. And this is one of those areas because in the psychedelic space, really the legal frameworks that are breaking out is the entheogenic approach, which is really based on spirituality and religion, and then the medical approach, which in the psychedelic space is really going more the FDA federal pathway. So we'll talk more about that a little bit later. So on the hemp side, what we see, I've broken it down between the different parts of the plant. So you have the flower of the hemp plant, you have the stalk of the hemp plant, which consists of fiber and hurd, and then you're going to have the seed of the hemp plant, right? These are all very different businesses with very different histories and very different policies behind them. So what you have for the flower is mainly the business segment that we're focusing on hemp when you're dealing with flower is the cannabinoids. There's CBD, there's THC, there's CBN, CBG, there's hundreds of cannabinoids. The main cannabinoid people are focused with right now from the hemp plant is CBD, right? That's the main focus. If you're dealing with the flower, you're trying to get it for CBD. Now, if you're dealing with the stalk, right, the fiber and the herd, what you're seeing is that there's a lot of different uses, a lot, way beyond just the flower uses. Right now, everyone puts the attention on CBD or CBN or CBG or smoking or eating a consumable. But what's the reality is that the potential uses for this plant, there's thousands of them. And that could be broken down as I show right here. There's the industrial textiles, which is the rope and the canvas, things like that. There's consumer textiles, which are apparels and fabrics. There's paper. And then there's building materials, which is like fiberboard and insulation. So there's tons of different stuff. You could pretty much make anything in this room, from the table to the chairs to cars, almost anything could be made out of hemp, other than things like glass and steel. Glass and steel can't be made out of hemp, but besides that, almost anything could be made out of hemp. So the potential for this industry is tremendous. Really, this was the main focus, right? And then people started getting excited about the CBD, but the next wave of what we're going to be seeing is really the interest in this, all the different uses for the hemp plant. Now, the third thing you're seeing the hemp plant used for is the seed. And from the seed, you could have oils, you could have paints, you could have varnishes. Lots of different stuff comes from the seeds. And seed oil is not to be confused with flower oil. In fact, seed oil from the FDA has actually been considered generally recognized as safe. So it is grass, these seeds. So for seeds, the FDA is very, very open and accepting. The FDA has taken a lot of opposition to, and we'll talk about that further in different classes. So what we're going to do is we're going to talk about the history and policy as it relates to all this. And the history and policy related to marijuana is very different than the history and policy related to the industrial hemp side, which is very different from the CBD side, which is very different from the seed history and policy. So the key topics that we'll be talking about today are, number one, is that cannabis has throughout history been used for industrial purposes. Now, these purposes, tens of thousands of years ago, we've seen these used, and we're going to talk about a little bit more about that history. We're also going to talk about the long history in the United States that this entire thing has dealt with. Then we're going to get into the Controlled Substances Act. So we saw a long history of how these cannabis plants got developed, and then the CSA, the Controlled Substance Act, changed everything. And we're going to talk a little bit about that. Then we're going to go through the difference between decriminalization and legalization, which is extremely, extremely important to understand as an attorney. We'll then talk about some of the banking issues that have been created by some of these policy issues. And then lastly, what we're going to talk about how important it is to stay on top of the cannabis laws that are constantly changing. So we're going to go to the next slide now. And so on the next slide, what we're going to be focusing on is the industrial use of cannabis. We're dealing with this right in here. And so hemp cord was first identified around 8,000 years ago in Taiwan. So it went from Taiwan, Asian markets, then it went to Europe, then it went to America, and all the while we were seeing things like rope, canvas, textiles, apparel, fabrics. All these things were being developed well before we even started exploring the medical uses of it. So it's very, very important to start looking at the economies that were created in these markets. The economies were tremendous. There was a huge demand for these products, yet there was a very limited supply. So from an international transactional perspective, there was a lot of trade going on amongst the different countries, and the supply chain was totally built out from certain countries that were focused on the growing, other countries that were focused on the decortication, other countries were focused on the secondary processing, and so on and so forth. And each country basically played their role in that supply chain. And that's exactly what we're seeing play out in current day today. And the clients I work with on the industrial, textile, consumer textile, the paper, the building materials, all those clients, what we are mainly focused on is looking back in history at that supply chain and trying to recreate that. So being able to understand the history and how the economies were created way back when is going to be abundantly helpful for you to advise your client on how to, for example, bring an insulation building material to market. So that's very, very important. So going to the next slide. So on this slide, we're going to talk about the history of cannabis in the United States. And really the history in the United States started in the 17th century. That's when cannabis cultivation in the United States started really taking off. And in the beginning, it really started with this right here. It started with the textiles, the rope, the canvas, the textiles, the apparel, the fabrics, the paper. In fact, paper, the USDA, which is a federal agency, back in the 18th century, they found that to make paper out of hemp as opposed to wood was 1/4 of the cost. So the USDA was trying to incentivize farmers to actually go out and make and grow hemp so that they could make paper a lot cheaper. And so, these are things that happened historically that right now we're seeing play out in the current day. Now that hemp is legal through the 2018 Farm Bill, there's an opportunity out there to create that supply chain to produce paper at that much cheaper cost from wood. So all these opportunities that we saw historically, we're now seeing play out in current modern day. And the more you understand that history, the better you're going to be able to basically execute on these new opportunities that have already been executed upon in the past. So what we saw in the 1800s is states like California, Georgia, Kentucky, Mississippi, the farmers were having a great time growing this, and it was in high demand and very low supply. So they were actually able to charge good amount of money, and a lot of farmers were excited about this. You started to see towards the end of the 1800s, actually in pharmacies and in stores, they started to sell the cannabis extract, which started really the medical research. And this medical research is key because a lot of the medical research that was happening in the 1800s and the 1900s, it got lost in the 1970s after the Controlled Substances Act. But today, we have clients that are acquiring that IP and that research and trying to develop new drugs and new research to build upon that old research. So if you're an attorney that does patent law or trademark law, or if you're just trying to give good advice to your client, it's important to understand the history of this medical research and what intellectual property is out there to acquire. What happened was in the 20th century, and in 1906, we saw the Pure Food and Drug Act. And that was really when they started regulating the labeling on these cannabis products. So you started them to first start really restricting on the labeling. Then eventually it moved into them starting to tax cannabis, and then eventually involved into actual criminalization of cannabis. And really, that's kind of the evolution that we're trying to undo through these different statutes, rules, and the policy making that's going on currently today. Now, we're going to get into this, the next slide right now, and the next slide is on the Controlled Substances Act. But to really put it in context, for this slide, I want to talk about psychedelics for a minute, because what happened is in the 50s, we had tremendous research going on with various psychedelic compounds, one of them being LSD. And LSD was showing tremendous efficacy for various indications, but in particular for alcoholism. And we had great research being done, tremendous efficacy Alcoholics Anonymous was actually using LSD as part of its treatment plan. But what happened is in the 60s, the hippie counterculture got their hands on LSD, started misusing it in ways. They started, bad things happen. What's really important to understand that in the 60s, there was really no responsible legal framework in which to consume these compounds. So what happened was the bad things that occurred, whether it was someone jumping off a building or going in front of a car or something horrible happening, it overshadowed the tremendous medical research that was happening before that. And I mention this because it's very, very important that we understand as we start to roll out this psychedelic framework and the cannabis framework, we need to do it in a responsible manner. Because if we do just full broad access and we don't do it responsibly, what's going to happen is bad things are going to inevitably happen. And then what's going to happen is they're going to have to come in and try to over-regulate it. And that's exactly what happened with the Controlled Substances Act. In 1970, they saw what was happening with the hippie counterculture, and they had a knee-jerk reaction, and they basically created the scheduling system in the Controlled Substances Act. There's 5 schedules. Schedule 1 being the drugs that are the most dangerous, and then there's Schedule 5, which are the least restricted. So what happened was they put cannabis along with LSD and all these other psychedelic compounds, they put them as Schedule 1. And what Schedule 1 means is that there's no medical use whatsoever. And number 2, it has a high likelihood for abuse, right? So no medical use, high likelihood for abuse. That's what's supposed to be in Schedule 1. Now, when you get into Schedule 2, you have things like cocaine. Cocaine, they believe, has some medical use, still a high likelihood for abuse, but it has medical use. So currently, ironically, under our scheduling system, cocaine is actually regulated to have a better medical use and a better safety profile, really, than even cannabis. And we all know with the research that's taking place right now, it just makes absolutely no sense, especially because LSD, psilocybin, all these other psychedelic compounds where there's tremendous research coming out on the efficacy of these compounds, there's medical use. So much so that the FDA recently has designated both MDMA and psilocybin as breakthrough therapies. So the idea that these compounds have no medical use is absolutely absurd. And we've actually seen this play out in the cannabis industry, where in 1985, we had Marinol approved, and Marinol is a synthetic version of THC. And essentially the way that process works is the FDA process goes through phase 1, phase 2, phase 3. Once the FDA approves a compound like Marinol, it then goes to the DEA to reschedule. And so what happened was the DEA rescheduled Marinol as a Schedule 3 compound, right? And then later on, in 2018, we had Epidiolex, which is a highly concentrated form of CBD, and that went through phase 1, phase 2, phase 3. The FDA approved it. Then it went to the DEA, and the DEA rescheduled it as a Schedule 3 compound. So now we're in this weird world where we have Marinol and Epidiolex, which are really made out of cannabinoids from the cannabis plant, even though they're made in a lab synthetically, that are Schedule 3, showing that there's medical use. However, we have this cannabis plant that is still listed as Schedule 1 with no medical use. It literally makes no sense whatsoever. We're also in a situation from a psychedelic perspective where we have the FDA designating some of these compounds as breakthrough therapies, yet these compounds are still listed as Schedule 1 compounds. And what we're going to see very soon is right now MDMA is in Schedule 3 with the FDA. And what's going to happen is, I believe, sometime around the year 2023, 2024, MDMA will be FDA approved and commercialized. The DEA then will need to reschedule MDMA. Similarly, psilocybin is in phase 2 clinical trials with the FDA. I believe in the year 2025 to 2026, psilocybin will be FDA approved and commercialized, which once again, then it will have to go to the DEA, and the DEA will have to reschedule that and make it appropriately scheduled. So we're really just taking the steps that are required. Unfortunately, in our system, that's what you have to go through. You have to prove out this efficacy through a very long and expensive process through the FDA, and then eventually they get rescheduled. So on this next slide, we're going to talk about decriminalization and legalization. These are two very important, distinct legal terms that you need to understand if you're working in cannabis or psychedelics. So decriminalization, essentially what that means, it's a bit of a misnomer, because when they decriminalize, whatever they're decriminalizing is actually still a crime. What they're doing is they're making it the lowest priority for the particular city or state, and they're saying that they're not going to allocate resources for prosecuting it. That's all they're saying. They're not saying it's no longer a crime to use and possess cannabis. What they're saying is that we are just not going to allocate resources to arresting people for these particular crimes. That's what decriminalization is. In contrast, legalization is actually creating a commercialized legal framework, right? So California was the first state to really decriminalize, and then you had Oregon and Washington in 2012 really create the first legalized recreational markets. And that's very, very important to understand. Currently, as of today of shooting this, there are 36 states that have legalized cannabis in some form, and about 16 states plus DC that have actually legalized it in its recreational form. So that's an enormous, enormous achievement. We've come an extremely long way. And what we're seeing play out in the psychedelic space right now is, as of today, we have cities decriminalizing psychedelics. So for example, Denver, Santa Cruz, Oakland, Ann Arbor, several cities in Massachusetts, Washington, D.C., they've decriminalized psychedelic plants and or some of the synthetic psychedelics as well, depending on the city or state. So those cities and states that I just named doesn't mean that it's legal there. It's not legal. What they've done is they've just made it the lowest priority, and they're not going to be enforcing it. So I get calls, once Denver decriminalized, I got calls nonstop from people, hey, I want to get into the mushroom industry. What can I do? And I had to explain to them, it's still a crime from a federal perspective to use and possess psilocybin mushrooms, still a crime from a state perspective, and the city saying it's decriminalized doesn't change any of that. All it means is that they may not arrest you if you are in possession or use. Now, if the DEA wants to come in, the DEA could do whatever it wants with respect to that. So that's the decriminalization. Now, in contrast, Oregon, through Measure 109, is the first state to legalize psilocybin mushrooms. So they've actually created a legalized framework where you could get a production license, a third-party testing lab license, a licensed service center, or a licensed facilitator license. So they now have a licensing structure where you could actually legally commercialize it. Now, that comes with a caveat. The Oregon framework, while now it would be legal from a state perspective, still is illegal from a federal perspective. Psilocybin is still a Schedule I compound and is illegal. So if the DEA wanted to come in to Oregon, even after they did their licensing process, they could very much come in and they can shut down those facilities, and they could arrest people, and they could do whatever they want. So there's decriminalization, which doesn't offer very much protection. There's legalization, which offers a little bit more protection. But then there's full federal legalization. We're going to get in a little bit later on about what's happening at a federal level, but it's very, very important for you to understand this distinction between decriminalization and then legalization as well. So going on to the next slide, we're going to talk about marijuana banking. Now, because of what I explained in this marijuana world, where you have the federal law saying that it's illegal, but you have some states, right now we have 36 states that have legalized it in some form. You have these states, so you have this dichotomy where federal law says it's illegal, some states say it's legal. If you're watching this course, you're probably an attorney and you understand the supremacy clause and you understand that federal law trumps state law. So even if something's legal from a state perspective, it's still technically illegal if it's still illegal from a federal perspective. So that creates all sorts of issues. One of the issues is 280E. What 280E is a tax provision. 280E basically says that these marijuana companies can only deduct cost of goods sold. So you don't need to be a tax guru to understand this. Basically, if you're in business, you have a lot of expenses beyond just your cost of goods sold. You have rent, you got overhead, you've got insurance. To the extent that any of those costs can't be allocated to cost of goods sold, they cannot be deducted. So marijuana companies have a very, very high effective tax rate. And we're going to get into that whole tax issue in future courses, but I just wanted to hit on it right here. What's also very, very hard for these companies because of the federal illegality is banking. And by the way, the banking challenges aren't just limited to marijuana. The banks are also still very hesitant to even deal with the hemp companies because this distinction of 0.3% is so minuscule. And what the banks are worried about is that they're required to know their customer. And the amount of diligence they need to do for a hemp client to ensure that they're not actually doing marijuana, for some of them they said, we don't want any of it. So some of this stuff I'm talking about, it's specific to marijuana, but it's important to keep in mind hemp clients of yours will have similar issues with respect to banking. So the big issue to understand, since it's federally illegal, as an attorney providing advice or helping set up one of these businesses, you could potentially be aiding and abetting a federally illegal crime. So just because we're giving legal advice doesn't mean that we're not aiding and abetting. I think everyone understands we can't go out and help a client set up a cocaine business, right? We'd be aiding and abetting in the crime. So similarly, lawyers have a challenge with our own ethical duties, which we'll get into in later courses as well. But for banks have the same issue. Their issue is that if they're helping all of these transactions and all these federally illegal transactions are flowing through them, then they technically are aiding and abetting a federally illegal transaction. So what has happened is that you really had a lot of different kind of things happen from a federal perspective to try to create some leniency for these marijuana companies. But without this leniency, these marijuana companies have to deal with cash. Now, cash is very, very challenging to deal with. Number one, you have to transport cash from place to place. Number two is the theft that occurs with cash, right? Cash, when you're carrying hundreds of thousands, if not millions of dollars of cash in your dispensary, there's a higher likelihood that someone may break in. So as a result, these dispensaries have to have all this security put inside them. They need to have vaults. They are probably more secure than a freaking bank is. And the reason is because they're dealing with cash because of these banking issues. So what has happened at a federal level for these banking issues? What's happened is the Cole memo came out. And what the Cole memo essentially said is that it basically told federal prosecutors not to allocate resources to prosecuting individuals that are operating legally from a state perspective, but more so that they're not going to enforce it on banks. And essentially they came up with these priorities, these list of priorities. And they said as long as the company is not violating these priorities, we're not going to come down on the banks, right? And those priorities are mainly focused on not distributing the product to minors, not engaging in any actual illegal activity or funneling money to illegal enterprises, right? What those priorities were focused on is saying if a company is operating legally from a state perspective, we're going to allow a bank to bank them, and we're not going to come down on that bank. What happened after that was FinCEN came out with their own guidelines, and then after that, we had the Session memo, which basically voided the Cole memo. But what's important is that right now, we're still basically operating under the Cole memo, but the Session memo was very, very important in that it actually reiterated that these banks are aiding and abetting federal crimes. So what's important for these banks that are banking marijuana is they're required to file SARs, suspicious activity reports. So a suspicious activity report, there's three kinds. There's either a limited, there's a priority or there's a termination. So a limited SARS report for a bank means that they had a suspicious activity, they researched it, but after their due diligence, it does not look like there's anything illegally happening from a state perspective. Now, what a marijuana priority says is that they had a suspicious activity, they did their due diligence, and it does appear there's a particular state law being violated or that it's being put into minors' hands or something wrongful is happening there. And then the marijuana termination is where the bank is just cutting their ties with that actual company because they are engaging in one of the, implicating one of the Cole memo factors. So it's very, very important to understand those three different types of SARS. And because of the additional cost that banks will have to incur for dealing with SARS, because of those additional costs, most banks said we don't want to deal with it. So as a result, a lot of banks just won't deal with marijuana. Now, subsequent to all this, what happened was the 2018 Farm Bill legalized hemp, and the banks were confused. They said, what do we do now? We can't really tell the difference between a hemp company and a marijuana company. So what happened was we actually came out with a policy statement from the federal government where they actually gave some guidance to banks. And in essence, there's several items, and you could read the course text, and it goes into great detail about what the guidelines were. But in essence, what they're telling the banks is that you don't need to file SARS for hemp companies as long as they have their hemp license and they could prove that they're not doing anything that shows that they're going above this 0.3%, which would put them into marijuana world. So the banks now should be able to bank hemp, but once again, you have the banks that are still being very conservative and they don't want to touch hemp, so they're just totally staying out of it. So the banking issue is a tremendous issue that you have to keep an eye on. If you, one of the first things a client asks me when they want to start their business is, could you help with banking? Could you help with payment processing? Could you help find me an insurance company? All these different services that are generally so easy for other legal businesses are just tremendous, tremendous challenges for your cannabis clients. So when you deal with a cannabis client, it's not just explaining the law to them. It's also being able to connect the dots and having the resources and knowing the banks you can go to. I have my go-to banks. There's 3 banks I currently use. When I have a client that has trouble getting an account at a normal bank, we have 3 banks that I could take them to. And that knowledge and those relationships I have at those banks, that's just as valuable as the legal advice that I'm able to provide those clients. Very, very, very important on the banking side. So going on to the next slide, what we have is I've kind of drawn out the evolutions of the laws and public policy. So really it's important to just have this in one chart in my opinion. So what we had is in 1906, you had the Pure Food and Drug Act. Once again, that was what required them to get labeled. All the cannabis products in the United States had to get labeled a certain way. Then in 1915, California became the first state to prohibit cannabis. Now, this is a bit ironic because we're going to see that California was also one of the first states to decriminalize in 1996. So it's important to understand California was actually one of the first states to prohibit cannabis. So in the early 20th century, the federal government allowed cannabis. It was actually the states that were starting to prohibit it, and now we're seeing the flip happen. So then in 1937, we started to see marijuana start to get taxed. Then in 1951 was the Boggs Act, which created some criminality. And then we had in 1970, the Controlled Substances Act. That's what made them Schedule I. That was the war on drugs. All research that was getting done for cannabis and psychedelics halted. Until about the late 1990s is when this research got picked up by nonprofits like MAPS and Beckley and all these other organizations that started picking it up and researching it. And now today, really the research we're doing today with cannabis and psychedelics is just picking up on the research we already had in the 50s and 60s that was stifled by the war on drugs in the 1970s. So in 1973, Oregon became the first state to decriminalize cannabis. Then in 1996, we had California become the first medical state 2012, we had Colorado, Washington become the first recreational states. Then we saw the Cole Memo come out, and that was a big turn in the 2013. That was really the first time the federal government acknowledged that we have this state legal framework and it's impossible to ignore. And that's why the Cole Memo is such an important turning point, and I really encourage any attorney watching this course to actually go into the Cole Memo and actually read the actual memo and understand what it says. Then in 2014, we had the Bank Secrecy Act. We also had the 2014 Farm Bill. Now, what the 2014 Farm Bill did is it kind of created this distinction, but it didn't legalize hemp. What it allowed people to do is start doing research for hemp. And what happened is in 2018, we had the 2018 Farm Bill. And that's what basically legalized hemp. So it took out, it said, the logic behind that was that Delta-9 THC is what gets people high, right? That's what everyone's so worried about, that Delta-9 is going to get people high. So essentially, what the federal government is saying in this 2018 Farm Bill, as long as it has 0.3% or less Delta-9 THC, essentially it's not going to get you high. So it's legal. And you can start getting the other benefits of some of the other cannabinoids, such as CBD, CBG, CBN. Now, what's also happening is there's a bit of a loophole that's developing commercially. If you are an attorney and you don't know what Delta-8 THC is, you need to understand what Delta-8 THC is. Delta-8 THC, derived from hemp, a lot of people are taking the position that it is now legal. Now, this is a very, very complicated issue, and we're going to get into this in further courses, but it's very important to understand the definition of hemp only focused on Delta-9 THC, but now we're discovering additional cannabinoids such as Delta-8 THC and Delta-10 THC, which might also have psychoactive effects, but it's possible that they still fall into the classification of hemp. So it's very, very important to understand definitions and key concepts, and we'll be going over some of this stuff in much greater detail in some of these future sessions. In 2021, the USDA had its final hemp rule, which was very exciting. It really went over things like how we should be testing it, how we should be destroying anything that gets hot, what are the repercussions for testing hot, and quite honestly, the whole process for these rules, I think, really brought the industry together, and ultimately we ended up with rules that I can stand behind and I could support. And then we also had the vape ban, which also came about this year. So this year was a huge year, huge momentum, and now there's two bills right now at a federal level that now the federal government is just saying we cannot ignore what's happening with cannabis, right? So what happened is the 10th Amendment really allows the states to be laboratories of experimentation, right? The states should be doing their own laws, and you have this patchwork of different laws, and ultimately whatever law works out best is what the other states will adopt. That's a concept behind the 10th Amendment. You have the federal government and then you have the state governments, and each of them are their own laboratories of experimentation. And really what we've done is we've run the experiment with cannabis, and the sky is not falling down. We had California legalized, Colorado, Florida. We've had 36 states legalized in some form, and the sky is not falling down. Quite the opposite. People are being helped by these compounds. The world is turning into a better place. There's higher tax revenues, better employment. Economies are doing unbelievably well. Cannabis is helping this world, and the federal government is getting to a point where they can't ignore that. And so what you're seeing is several bills that reflect that. And so the two main bills that as an attorney you need to pay attention to is the Safe Banking Act and the States Act. So first we'll deal with the States Act. And what the States Act is, it's really just a reinforcement of the 10th Amendment. What the States Act does not do, it does not legalize from a federal perspective cannabis. It does not do that. It doesn't deschedule it. It does not reschedule it. That's a huge misconception. What the States Act does is it essentially differs to the states on their position for cannabis. So if a state says that they allow medical cannabis, the federal government will respect what that state says, right? It doesn't legalize it from a federal perspective, but it defers to the state. Now, if a particular state says that cannabis is illegal, it will still be treated as illegal from a federal perspective. So the States Act is something that I'm a huge advocate for. I think it would be a tremendous step forward. I do not think that it's in the very near future. Now, the Safe Banking Act is something a little bit more limited. Safe Banking Act essentially just provides bank services a little bit more protection for banking cannabis companies, right? There's so many issues right now with the fact that these cannabis companies have to handle cash. I mentioned the security issues. I mentioned that there might be theft. I mentioned that it's just more of a hassle for people to have to handle cash. But what also we saw transpire recently with the pandemic is that people having to hand over cash carried coronavirus. And so you actually saw in one of the Corona bills language from the Safe Banking Act, because something had to happen. These dispensary employees, which their business was designated as essential during the pandemic, they had to handle cash and put themselves at a higher risk for corona just because of these federal laws that just make absolutely no sense. So the Safe Banking Act is something that much more specific to banks. So I get asked a lot, where are we with federal legalization? When will we have federal legalization? And in my opinion, I don't believe the States Act will pass. We're not going to see anything that broad. But what I do think we're going to see in the next couple years, and right now we're recording this in 2021, so I think what we'll see in 2022 and 2023 is I think we'll see some easing of banking restrictions and also 280E tax restrictions. So I don't think the federal government will just fully legalize cannabis. I don't think they'll deschedule cannabis. But I think what we're going to see is they're going to make it easier for these cannabis businesses to do business. And the two ways they could do that are by easing restrictions on banking and then easing the 280E issue as well, which, like I said, we'll get into in the next course. So before we get into the do's and the don'ts, I want to talk about one more policy issue that is tremendous in the cannabis industry, and we're going to be getting into great detail on this particular issue in future classes. And that other policy issue is social equity. Social equity plays a tremendous, tremendous role in the cannabis industry. And quite honestly, you cannot be a cannabis attorney if you do not understand the policy behind these social equity statutes and provisions that we have. So each state has their own way of having social equity programs. Some states don't have social equity programs, but the key concept with social equity is essentially righting the wrongs of society and creating some sort of advantage for the communities that have been disproportionately impacted by the war on drugs. So the way they generally will do that is they will actually say that particular communities have been impacted because they've been arrested for low-level cannabis offenses. So that's possession and use of a low-level cannabis offense. If you've been arrested and your life has essentially been destroyed because of this scar on your record, and that's the case, a lot of people have been arrested for these low-level criminal offenses, and now they need to report that to every single prospective employer, and they have tremendous difficulty getting a job. What the social equity programs are trying to do is giving those people an advantage to get licenses. So when you're doing licensing in other states, and we'll have a course on licensing, it's very, very important you understand those social equity aspects to it. So I'm now going to roll into the do's and the don'ts. So it's very important. I'm very appreciative that you guys have stuck with me, but it's very important that you understand the key concepts. And the first do that you need to understand is you do need to understand and remember that the Sessions Memorandum permits any state legal business to be prosecuted for violating federal law. Now, I don't say that to scare you, but it's very important for you as a lawyer to protect yourself, and you need to advise your client of this in writing. In fact, you may even want to put it in your engagement letter, but you also should explain that really there's been no enforcement action and it's not really something that is extremely high risk, but it's something as a lawyer you need to make sure you put your client on notice of. You also need to be prepared to spend time researching financial institutions that provide financial services for your clients. If you are in New York, you better have 2 or 3 banks that you know will bank your cannabis clients. If you're in Florida, you better have 2 to 3 banks you know in Florida that will bank your cannabis clients. Make sure you develop those relationships, because those relationships will be just as valuable as the legal advice you provide for your client. And also make sure you stay abreast of each state's marijuana and hemp laws. Each state has their own patchwork of laws. There's no unified marijuana, hemp, cannabis laws. Each state has their own way of doing things. So it's very important, as more of these companies become MSOs, multi-state operators, it's more important for you to really track and understand each state's laws so you could properly advise your client. Now, my don'ts, don't forget that state law enforcement, the DA, have the authority to raid a state legal marijuana business. It's very important. Once again, these are disclosures and things you want to put in writing to your client. Also, the DOJ has authority to prosecute any state legal marijuana business. Once again, you need to fully advise your client, and you need them to understand the risk that they're taking by doing any of these activities. Don't forget about the banking with the marijuana related business creates a lot of risk. Now, I've seen different clients deploy different strategies for banking. I've seen them create legal entities that may not have the word cannabis in there, get banking, and then file for a DBA that has the word cannabis in there to kind of get around some of the bank things. The reality is you should never lie to your bank, and you should never misrepresent any information. There's ways to get banking without doing anything illegally. And also, do not mix up the difference between decriminalization and legalization. That could be very, very dangerous for a lawyer to not understand. If someone were to think that Denver decriminalized magic mushrooms and therefore they're legal, and a client calls you to understand that, and you think that the decriminalization means legalization, you're going to give him some very, very bad advice. And this is not bad advice that just turns into a civil lawsuit. That client could potentially be criminally liable, which makes you even more liable for professional liability. So you need to be very careful to make sure you understand those do's and those don'ts. Thank you very much for joining in this coursework. I know you've probably learned a ton of information. I want to make sure you guys also don't just watch these videos. Take a look at the textbook that we're providing. Take a look at the slides, because really reading all of that together is what's going to create the full and entire picture. And make sure you tune into our future classes as well, because the future classes will provide further context for what we discussed today.